mother's obsessive love leads to murder.
I did once tell Mel I was going to meet my father. She tried to kill herself.
For a loved child, there's nothing one wouldn't do.
A stirring psychological thriller, Mother Love, on Mystery.
From now on, I shall live my life through you.
Enjoy 4 hours of mystery, Thursday at 8.
The week of September 29th. Mark it on your calendar.
Showcase Week begins September 29th.
You're watching Iowa Public Television.
Worth watching, IPTV.
This week's American Interest program will be preempted for the following Public Affairs Special Report.
Funding for this program was provided by the Corporation for Public Broadcasting and by the financial support of viewers like you. From Washington, D.C., highlights from today's Senate Judiciary Committee hearings on the Supreme Court nomination of Clarence Thomas.
I'm Paul Duke at the Capitol, where the Senate Judiciary Committee continued its hearings on the nomination of Judge Clarence Thomas to the Supreme Court. Today, public witnesses came forward to give their views either for or against the nomination. The lead-off panel consisted of a group of law professors who voiced some very serious reservations about the choice of Judge Thomas.
I think it's been very difficult, Senator Kennedy and Senator Thurmond, for many people to come to grips with how they would respond to the nomination of Clarence Thomas, and I certainly include myself in that category. It has not been easy coming to a determination. But one of the things that I was concerned about, and I think that thinking was very much affected by the opening statements that many of you made at the beginning of these proceedings about the role of a justice of the Supreme Court, about the role of the Supreme Court as a guardian of individual rights. I think Senator Heflin talked about the Supreme Court being the people's court, dealing with real issues and real people. And Senator Thurmond, you talked about its responsibility to administer justice, to be concerned about that standard. And what I tried to do was place Clarence Thomas in that context as a guardian of individual rights, as a member of a people's court. And the more I did that, the more difficult I found it to envision Clarence Thomas as the next Associate Justice of the Supreme Court. My conclusion was very much affected by two things. First, reading his writings and reviewing some of the speeches that he's given on issues of concern to me and issues that I've dealt with for most of my professional life. What strikes me about his articles and his speeches is their detachment from history, his treatment of these issues as though they arose only yesterday, or indeed in some cases the day before he began to speak about the issues, rather than as a consequence of very long and difficult and hard and painful efforts by a number of people, including civil rights groups, to deal with problems of discrimination and exclusion. For example, on the issue of goals and timetables, he rejects goals and timetables as a technique for dealing with discrimination in employment. But as we both know, although Judge Thomas does not seem to recognize this in many of his public positions prior to becoming a judge on the Court of Appeals, that goals and timetables were a response to years of recalcitrance and resistance by employers and unions to efforts by civil rights groups and individuals to get employment opportunities on a fair basis. He talks about school desegregation and criticizes Green versus New Kent County, a very important case in 1968, as though it were a concoction of the Supreme Court and not a response to years of massive resistance by school districts all across the country. In fact, I found it somewhat interesting when Judge Thomas talks about his experiences that there's no reference to the fact that in his hometown, Savannah, Georgia, for many years, people were fighting just to get one black child into a desegregated school. In fact, in Savannah, for some years until the courts intervened, black children were being given IQ tests and all kinds of psychological batteries to determine whether they were suitable to sit next to white children in schools that had been segregated in the past. He also talks about questions of discrimination in other areas, voting rights particularly. And once again, as you know, Senator Kennedy, for many years, the Justice Department and other private individuals tried to deal with voting discrimination without success. And it was required for the Congress to come in and pass the Voting Rights Act of 1965. And when Congress extended the Voting Rights Act in 1970, in 1975, and most recently in 1982, it was responsive to real, not imagined problems of discrimination in that area. The second concern that I have about Judge Thomas is his role as a civil rights enforcement official in both the Reagan and Bush administrations. Judge Thomas has attempted to compartmentalize his life into what he was before he became a judge and the fact that he's a judge now. But the truth is he was occupying a position as a bureaucrat that was set up by Congress because of its view that people needed special protection. There needed to be an Office for Civil Rights in the Department of Education. There needed to be an EEOC to make certain that people who were systematic victims of discrimination could get some relief. And I think the way he occupied those two positions, for example, in the Title IX area in the Department of Education, not seeing the necessity for extending Title IX to discrimination against women in education, and his treatment of his responsibilities in the EEOC did not reflect the type of sensitivity to that special responsibility and role that he had in the federal government. Thank you very much.
Thank you very much. Professor Edley.
Thank you, Mr. Chairman. In summary, my central point is this. The Constitution forces the executive and legislative branches to share responsibility for picking justices and thereby share influence over the course of constitutional history. In taking the measure of the nominee, you should look to the whole record and recognize that good character and unimpeached integrity did not prevent Dred Scott or Plessy or Lochner. In the final analysis, it is not the character of this man that must be at issue, but the character of his record. Yet the heart of the administration's affirmative case is Judge Thomas's personal story and character, in hopes perhaps that this strategy will undergird his credibility and present an image strikingly more attractive than piles of speeches and abstractions. But that voluminous record raises many grave concerns to which the nominee offers one of three responses. First, quote, although what I said may sound extreme, I was really trying to make a far less controversial point. But repeated so often, this seems to me to lack credibility. Second, quote, that was the position I took as a policy official in the executive branch. As a judge, I do not make policy. This argument is wrong. It misconceives the role of the Supreme Court and the process of judging. Third, quote, I have an open mind on that subject. When applied to fundamental matters, however, this is almost disqualifying. A well-qualified nominee should at least be able to suggest, however tentatively, the framework for his or her analysis. How else can you discern someone's constitutional vision, which is the key question before you? You have his documents to analyze and you have his credibility to assess, but here's what I believe you are left with in two of the more critical dimensions, civil rights and separation of powers. First, in civil rights, the close questioning, particularly by Senator Specter, did not demonstrate that the nominee's views fall within the broad bipartisan consensus. If Judge Thomas joins the court, this court that gutted Griggs in a fit of activism, what grounds are there for confidence that he will dissent from further judicial activism of the same sort? Judicial activism to reverse those statutory and constitutional holdings he attacked so forcefully for so many years. The second critical dimension is broader. Judge Thomas, on his record, is certainly an unlikely congressional pick for referee or partner in the separation of powers structure. Why so? Well, the pattern of intemperate remarks, Senator Metzenbaum replayed some of them yesterday, the repeated clashes with oversight committees, the cramped and even distorted reading of Title VII and of judicial precedents. Senators Specter and Kennedy explored these. The pattern, it seems to me, is compelling. The fair prediction, I believe, is that Justice Thomas would tilt strongly toward the executive, defer to narrow agency interpretations of statutes, lean against generous interpretations of regulatory laws, including civil rights measures, and probably be uncharitable in appraising the rationality of statutes within the framework of due process or Section 5. The court's referee role, however, is more critical now than ever. We seem ever more ambitious as a people about what we want to accomplish collectively through one or another level of government. And divided government, that is to say, the White House and Congress, led by different political parties, spawns conflicts, which courts must often resolve. These separation of powers tensions are implicit almost everywhere, but statutory interpretation with an agency arguably hostile to congressional will is the most common setting. Let me be plain. When you choose to confirm or reject a nominee, you influence the Supreme Court's jurisprudential view of statutory interpretation and the role of the executive. You influence, perhaps profoundly, the balance of power. Rust v. Sullivan, the abortion gag rule case, shows the danger of a world where, even if Congress has passed the law, executive agencies can distort it, the Supreme Court can misinterpret it, and when Congress tries to clarify its own intent, the president can veto it. The design of the framers seeks to balance factions and ensure that no branch has ideological domination over the others. With that in mind, Mr. Chairman, the lax and deferential standard for confirmation proposed by some makes little sense. Can it be now that the greatest danger to the separation of powers is not the abuse of executive power or an overreaching judiciary, but the unwillingness of Congress, in this instance the Senate, to wield its power? If there is a new Thomas standard, it will be by your choice. You will be choosing evasion over candor, conversion over consistency, political scripts over constitutional debate. But I believe you will choose well. Hope this has been helpful.
Thank you very much. Lawrence?
Mr. Chairman, Senators, it is with considerable anguish that I come before this committee to oppose the confirmation of Judge Clarence Thomas. No one who has himself experienced the headwinds of American racism can easily oppose an individual who has traveled the same buffeted road. No one who has been participant and witness to the courageous struggles that have opened doors so long closed to us is anxious to say that one of our own should not pass through those doors. But after a long and careful consideration of Judge Thomas's record as a public official, after listening to his testimony before this committee, I find that I must oppose him. When Judge Thomas made his opening statement before this committee, he invoked the legacy of Justice Thurgood Marshall. He said, Justice Marshall, whose seat I have been nominated to fill, is one of those who had the courage, the intellect, to knock down barriers that seemed so insurmountable. When I heard that invocation, I wished with all my heart that this was a man capable of fulfilling that legacy. I wanted to believe that he knew what it meant to stand on the shoulders of this great champion of racial justice, that he was an individual with the acuity of intellect, the integrity, and the strength of character to carry on the monumental vocation that was Justice Marshall's. I knew that millions of black Americans shared this longing with me. Justice Marshall was our first and only voice on the nation's highest court, in the judicial conference room, on the pages of the Supreme Court reports, in the public discourse. We counted on him to make our story heard. On a court increasingly insensitive to the plight of those denied full fruits of citizenship, he was also a voice for women, for gays and lesbians, for the poor, and for other minorities. This is Justice Marshall's legacy. And those of us who believe in the court's special role as guardian of those without voice must do more than hope and trust in Judge Thomas's invocation of that legacy.
Some people argue that it's important that a black American sit on the Supreme Court, and that if Judge Thomas is not confirmed, it's highly unlikely that President Bush will nominate another black American. What weight do you give that in terms of the support for Justice Thomas? So, Lawrence, maybe we'll go the other way this time.
I think that I certainly would feel that it would be a tragedy of President Bush, because we found his first African-American nominee wanting, would not choose from among a wealth of other African-American nominees who we would find be quite ready to support, even from his own party. So I think that would be a tragedy if this were used in this way. At the same time, I also feel that, as retired Justice Thurgood Marshall admonished us upon his retirement, that the important issue here is not the color of the nominee's skin in terms of a voice for our community, but the nature of that voice. So that for me, I think that certainly I would hope that the president would find another nominee from within the African-American community. And there are many, many who I feel are extensively more experienced, extensively more qualified than Judge Thomas. At the same time, I feel that if I'm given the choice of a person who shares with me only the color of my skin and a person who will speak for the interest of my community, I will choose the latter.
I would paraphrase some responses to this that were given in a report issued by the Congressional Black Caucus Foundation recently. Diversity is important, and we do value the goal of having an African American on the court, but we do not value it above all else. We don't value it above some of the principles that we've been discussing on this panel. It seems to me that the choice is not properly understood as take this conservative black or a white conservative. It seems to me the choice is between taking this very conservative black now or waiting for another African American or other minority of more mainstream views. If not appointed by Mr. Bush, then appointed by the next president. I think on the scale of decades in which the Supreme Court operates, we are willing to be patient still.
Senator Kennedy, as I indicated at the outset, this has been a very difficult situation for, I think, most African Americans and most people of goodwill in this country, because it would give me great pride to see another African American sit on the Supreme Court. But to follow my colleagues on this panel, I want to see something below the skin, beneath the skin, that convinces me that that person will be a voice and a vote for the people who are voiceless and voteless on the Supreme Court, particularly during this time on issues that are of critical importance to all of us, and issues that will affect us for as long as certainly the people on this panel will be alive.
Next came a panel of those who've known Thomas well and strongly endorse his nomination.
Clarence Thomas was no stranger to the indignities suffered by the Jim Crow laws, because of the Jim Crow laws. It was not easy to have to swim at a beach for blacks only, to be served food through a hatch at the back of a restaurant in the pouring rain, a restaurant only whites could enter, or to be required to pay for that food before it was given, to ride always in the rear of the bus, and to see their parents suffer like indignities. Such treatment could easily leave a person embittered and scarred. But such is not the person we meet in Clarence Thomas. Even in his early years, Clarence was an independent thinker, one who challenged the status quo. Is it any wonder then that at a young age he questioned the daily recitation of the Pledge of Allegiance, which ensures liberty and justice for all, when neither liberty nor justice was available to black children? We perhaps begin to see here the early beginnings of a judicial mind so ably demonstrated in these hearings. I taught Clarence Thomas in the 8th grade. He was a regular, fun-loving boy. He was cooperative and studious, willing to give a helping hand to those less able than himself. He was always grateful to those who provided a home for him and to the sisters who taught him. He seemed to recognize and appreciate the sacrifices others made for his betterment. Even in later years, after his appointment as chairman of EEOC, Clarence Thomas showed his gratitude by making a special visit to Boston to thank me and the other sisters who taught him. I might add that of the 1,000 and more young people who over several years graduated from my classes, Clarence was one of the few who came to say thank you. His question on this occasion was a searching one. Why was it that you sisters could do so much for us black kids that nobody else could or did do? My answer had to be that as followers of our foundress, who like St. Francis loved God and his poor, we too would love God in the person of these children, put especially in our care. During these hearings, much has been said about certain speeches and writings of Judge Thomas. One speech with which I am familiar has not been referred to thus far. I am referring to a speech delivered to the Franciscan sisters in a fundraising appeal. It is dated April 8, 1986, for your easy reference and reading, and I highly recommend it. What has since become a national concern was then a grave concern for Clarence Thomas. He said, and I quote, "What we had yesterday is precisely what we need now, as a bare minimum, as an indispensable starting point. That is God, values, morality, and of course, education. The sisters accepted our Equality Without Civil Rights Act. They accepted equality of education without a Supreme Court decision. They lived in the inner city with us before we knew that it was an inner city. Judge Thomas has not forgotten his roots. He lived day by day the cruel story of discrimination. He knows the results of being on the wrong side of the law, not because of what one has done, but because of the color of one's skin. I am most grateful for having this opportunity to testify in favor of Judge Thomas's confirmation as a Justice of the Supreme Court. The road from the unpaved streets of our parts of Savannah to these hallowed halls cannot have been an easy one to travel, but Clarence Thomas has demonstrated that he has overcome obstacles that might have defeated a lesser man. Thank you.
Thank you, Sister. President Brooks.
Judge Thomas is an active member of our board, concerned about all those things board members ought to take seriously: educational quality, finances, student and faculty productivity, and the like. However, I would like to limit my remarks to characteristics I've observed in him, which I suspect have some bearing upon his fitness to serve on our highest court. They are his energetic concern for the education of all our young people, especially for those of minority backgrounds, and his very practical approach to obtaining it for them. Judge Thomas is a realist. He knows the essential part which a good, solid education has played in his own rise from abject privation to prominence. And he knows that it is the key which will unlock the same doors for others. Judge Thomas has been an active recruiter of minority students for Holy Cross, making the college known to them, assisting them in the application process, and making sure that once enrolled, they do not drop out. I find it difficult to recall a single meeting of the Board of Trustees during which Judge Thomas did not question the administration of the college, including the president, about the status of minority recruitment. How many African American students did we enroll? How many had applied? From which high schools? With what SAT scores? About the status of financial aid for minority students? About the relative rank and class of minority students? About the social climate for minority students? About the graduation record of minority students? With a willing acknowledgement that minority students might need and be given some special and supplementary counseling, Judge Thomas insisted always that every student be held to the same standards of excellence, that each one be given the opportunity and effective encouragement to attain excellence. As a trustee, Judge Thomas met frequently with African American students at Holy Cross. On occasions of his visits to the college, he scheduled meetings with our Black Student Union so that he might have a first-hand personal knowledge of those students with a background like his own. Over the years, he became a kind of role model for our African American students. And in speaking with them, he was never stingy with either advice, know-how, or making the right connections for them. His message was never an easy one, but it was real and it was practical. Work hard, make the best of every opportunity, and know that we are here to help in every way we can. Judge Thomas is a practical man. He is well aware that the board, room, and tuition costs at a private four-year liberal arts college like Holy Cross are far and beyond the financial resources of almost all minority applicants. He has been constant in his support for our Martin Luther King Jr. Scholarship Program for African American students, which makes possible for others the same brand of opportunity which was made possible for him. Over the past few months, you have heard and read a great deal about Judge Clarence Thomas. My personal knowledge of him convinces me that he is a man of compassion, good judgment, and intelligence. His zeal for justice, freedom, and equal opportunity for all Americans is well known to us at Holy Cross. Our highest court will be greatly honored and enriched by his service. I thank you, Mr. Chairman.
Thank you very much, Father. Judge Gibbons, it's good to see you again. You were, I should note for the record, everyone in the Third Circuit took and takes great pride in you. You're one of the fine judges in this country, and it's a pleasure to have you here.
Until September 6th last, I was vice chairman of the board of trustees at Holy Cross College, and it was in that capacity that I came to know and to respect Clarence Thomas. In my dealings with him, I was left with the clear impression that Judge Thomas is intellectually gifted, open-minded, not doctrinaire, and receptive to persuasion. He is, I'm convinced, anything but the rigid, inflexible conservative that some have charged him with being.
My name is Niara Sudarkasa, and I'm pleased to have the opportunity to appear before you today in my capacity as an individual scholar who supports the nomination of Judge Clarence Thomas for the U.S. Supreme Court. In my view, Judge Thomas has the education and experience, as well as the intelligence, integrity, and high ideals necessary to serve on the nation's highest court. But much of the debate over Judge Thomas's nomination has focused on his ideology rather than his qualifications. And if I may, I'd like to make a few comments in this regard. Many who oppose Judge Thomas and some who support him seem to have assumed that his ideology could be pigeonholed and used to predict the positions he would take if he were on the Supreme Court. But what I have read by and about Judge Thomas, and from what I have heard this week, I believe, as others have said, that he is an open-minded and independent thinker, not one with rigid, prepackaged views. He has been characterized as insensitive to the concerns of African Americans. Permit me to submit that I think because of his independence and his keen sense of justice and fairness, Judge Thomas looks at all sides of issues when others might be content to examine only one. For example, Judge Thomas wrestles with the issue of individual rights when considering group entitlements, because he knows that fairness and justice are not one-sided concepts. He struggles with the points of conflict between the principle of equality and the practice of affirmative action. But because of his open-mindedness, I believe Judge Thomas can be persuaded to see, and indeed has been persuaded to see, that in order to redress past discrimination, the concept of equity, rather than strict equality, has to be applied. The Constitution speaks of equality, but it also speaks of justice. And under various circumstances, the principle of equity must be applied in order to ensure that justice and fairness will be the end result. Today, as we anticipate the appointment of Clarence Thomas to the Supreme Court, we see in him a leader with a different voice for a different time. We who have put our faith and confidence in him do not expect that he will abandon the quest for equal rights. As a matter of fact, we come forth now to challenge him to choose well the means by which he will carry on the quest for justice and equality. We ask him to be ever mindful of the words of Robert Hayden, the celebrated African-American poet, who suggested that we must not rest until it is finally ours, this freedom, this liberty, needful to man as air, usable as earth. Senators, I would say to you and to Judge Thomas, whose nomination I support, as a nation, we must not rest until Dr. King's dream becomes a reality. We cannot rest until we as a people have overcome.
These witnesses were followed by distinguished lawyer Erwin Griswold, who testified against the confirmation of Judge Thomas.
Dean Griswold, welcome.
Thank you, Senator. Obviously, I can only summarize. It seems to me, however, that the present hearings have left open several basic and important issues. No one questions that Judge Thomas is a fine man and deserves much credit for his achievements over the past 43 years. But that does not support the conclusion that he has as yet demonstrated the distinction, the depth of experience, the broad legal ability which the American people have the right to expect from persons chosen for our highest court. Compare his experience and demonstrated abilities with those of Charles Evans Hughes or Harlan Fiske Stone, with Robert H. Jackson or the second John M. Harlan, with Thurgood Marshall or Lewis H. Powell, for example. To say that Judge Thomas now has such qualifications is obviously unwarranted. If he should continue to serve on the Court of Appeals for 8 or 10 years, he may well show such qualities, and I hope he does. But he clearly has not done so yet. I have no doubt that there are a number of persons, white, African American or Hispanic, male or female, who have demonstrated such distinction. I do not question that the President has the right to take ideological factors into consideration, and it seems equally clear to me that this committee and the Senate have a similar right and power. But that is no reason for this committee or the Senate approving a presidential nominee who has not yet demonstrated any clear intellectual or professional distinction. And the downside, and this worries me profoundly, is frightening. The nominee, if confirmed, may well serve for 40 years. That would be until the year 2030. there does not seem to me to be any justification for taking such an awesome risk. Judge Thomas's present lack of depth seems to me to be demonstrated by his contact with the concept of natural law. He has made several references to natural law in his speeches and writing, though it is quite impossible to find in these any consistent understanding of that concept. This is very disturbing to me because loose use of the idea of natural law can serve as support for almost any desired conclusion, thus making it fairly easy to brush aside any enacted law on the authority of a higher law, what Holmes called a brooding omnipresence in the sky. That is bad enough, but the nominee has now said to this committee that he does not think that natural law plays any role in constitutional decisions. And this is frightening indeed, for it is quite clear in the 200 years of this country under the Constitution that natural law concepts do have an appropriate role, sometimes in modern times called moral concepts, law and morals, not in superseding the Constitution, but in construing it.
I have one question. Senator Kennedy wanted very much to be back to ask this question of the panel, and I asked if I would ask it on his behalf, and that is, gentlemen, what do you anticipate the impact on the past 25 years of progress on civil rights would be if Judge Thomas's views, as you believe them to be, prevail on the Supreme Court?
Judge Thomas alone is very important on that question, but we already have on the court a number of far more conservative justices than we have seen for many years. And the real substance of the question is what would be the impact of the last four appointments. And I think, in my view, it will be disastrous. I think it will stop in its tracks the slow but steady progress we have been making. Let me just add, Senator, that I think my interest in civil rights goes back to the time when I was in the 4th grade in the public schools in East Cleveland, Ohio. And for the first time, I had in my hands a copy of the Constitution. And I was about 10 years old, and I read it. And I raised with the teacher problems about voting in the South. And the teacher said to me, and I pointed to the 15th Amendment. The teacher said to me, well, that's the part of the Constitution that is not enforced. And I remember that just burned me up at age 10. Here's a Constitution. This is us. This is our government. But there's a part that isn't enforced. And as I look back, I think that then and there I decided I was going to try to do what I could to try to see to it that the Constitution is enforced, including the 13th, 14th, and 15th Amendments, and that we have real due process of law and real equal protection of the laws. Nothing really much happened until the early Many of the current generation are not aware of how much things have improved, but they have improved. But the task is by no means done, and I feel that that is one of the important issues before this committee and the Senate now, whether we shall erect another obstacle towards the eventual achievement of true equal protection of the laws of all persons in this country.
Yale Law School Dean Guido Calabrese testified that he believes Judge Thomas is well qualified for the Supreme Court.
I did not teach Judge Clarence Thomas, but because some of his closest friends in law school were students of mine and were people to whom I was especially devoted, I came to know him well when he was at Yale. He was at the time an admirable person who demonstrated a capacity for independent thought that is always unusual, but is especially so among students, for they tend all too frequently to conform to the current mood. His approach to law when he was a student was not especially linked with the left or with the right. What characterized him was that he could not be predicted, that he was always seeking more information in order to decide what made sense to him, and that whatever position he took was his own and was powerfully and eloquently held. Because of this, I recommended him to Senator Danforth, who was looking for an able youngster who could think for himself. I was glad I did so then, and I'm glad I did so now. Many of his views have changed several times since those days. That does not surprise me. It is almost inevitable with people who are truly struggling with ideas and wrestling with the great issues of the day. I would expect that at least some of his views may change again. I would be less than candid if I did not tell you that I sincerely hope so, for I disagree with many, perhaps most, of the public positions that Judge Thomas has taken in the past few years. But his history of struggle and his past openness to argument, together with his capacity to make up his own mind, make him a much more likely candidate for growth than others who have recently been appointed to the Supreme Court and who, whatever they may have said at their confirmation hearings, had in fact been set in their ways and immovable back to their law school days. Such a capacity for growth as a justice develops his or her own constitutional philosophy is essential if a person is to become a truly great justice. None of the great justices of the past, not Justice Black, nor Justices Harlan or Stewart, not Justice Holmes, nor Justices Brandeis or Cardozo, not even Justice Frankfurter, for all his years of teaching constitutional law, came to the court fully formed. The court itself and the individual cases that came before them shaped them, even as they shaped the court. In the end, it was a combination of character, ability, and willingness to work really hard, and openness to new views that made them great justices. These qualities, if there truly is openness, matter far more than past positions. Many a justice has changed his mind dramatically since going on the court. I hope and believe that Judge Thomas has these qualities, and that is why I'm here today. This is an extraordinary time in the history of the court. It has been 24 years since a Democratic president has nominated a justice to the Supreme Court. And that is as long a time, perhaps as there has ever been in the history of this country, certainly since the Civil War. From 1860 to 1884 was a period of equivalent time. At other times, when there has been such an extended period of time, the president has attempted to name people to the court whose views are very different from his own. Presidents Roosevelt and Truman, for what seemed an eternity but was only 20 years, named all the justices and made a point of naming some justices who were very conservative and some from the other party. Justice Reed, Justice Byrne were Democrats and very conservative. Justice Burton was a Republican.
I doubt whether we're ever going to see that enlightenment in this administration.
This administration and the past administration have not done so. Under these circumstances, they have continued to name people whom they thought would share their views. And that is their right in the first instance. But under those circumstances, I think that we have to hope that the people they have named at least have a capacity for growth, which some of the previous people who were nominated and who had, in my judgment, a less distinguished, Dean Griswold was quite candid in saying that some at least were no more distinguished a record than Judge Thomas. But those people did not have a capacity for growth which Judge Thomas has. I hope that in the future the administration will be more open to other views, but in the meantime, I think we are bound to hold people to the standard you have held in the past, especially when this is a nominee who has some capacity for growth, which I didn't discern in some of the earlier ones.
Well, your opinion is, I respect you very much, Dean, as thousands and thousands of lawyers across this country do, and I mean that sincerely. And of all the testimony that's been received, yours is the most persuasive to me in the sense that if I do not factor in what you are talking about, I quite frankly find it hard to find a sufficient rationale to support Judge Thomas. Because, as has been pointed out by you, other presidents in similar periods have understood the wisdom of having the third branch reflect a diversity of view on the great issues of the day. I do not observe that occurring, and as you know, as a student of history, and the one thing I can say, it sounds self-serving, but I have become a student of the history of the court after having to do so many of these and spent a great deal of time with your colleagues and professors of the law and legal scholars. And I know for certain that in all those instances where the presidents have attempted to remake the court in their own image, they are the instances, and essentially only the instances, in which the United States Senate has said, all right, if that's the way you're playing the game, then we must play it the same way. I yearn for the days, especially if I remain chairman of this committee, I yearn for the days when the president, Democrat or Republican, picks a nominee simply based upon their overall instinct about what their capacity for intellectual capacity is, and not on what their views are. I trust President Bush. I believe he's an honest man. But I doubt whether there's a single American out there who believes that President Bush said, by the way, just go find me a nominee who has an open mind. Just find me a nominee who has integrity. Just find me a nominee who's schooled in the law. I ask no more. Johnson Nuna would have apoplexy if that were the call. I just can't fathom that having happened.
I can't imagine that that happened either, Senator. On the other hand, it would be ironical if the test were the one which you are now proposing and that were applied for the first time to someone who has more promise of growth, who at least has experienced life in a way that the previous nominees had not, who knows these things, and who, insofar as he is showing these views of the administration, is in that particular also at odds with many of the friends that he made all through his growing up. That is, that the person who is doing this has shown more independence, although an independence in a direction that I don't share. So it would be quite ironical to find that person being turned down for this when the others just got through with all sorts of people, even people who are opposing this one, clapping their hands.
Up next, a panel representing the views of women and minorities who oppose the Thomas nomination.
Chairman Biden, members of the committee, as a black woman, it is exceedingly difficult for me to oppose the nomination of a black individual who has known great personal struggle. Nevertheless, Judge Thomas's extensive record and personal posture is so antithetical to the interests of women and blacks, especially black women, that I feel an obligation to testify against his nomination. Much has been said of Judge Thomas's rise from Pinpoint, Georgia to the federal bench. And without question, the Supreme Court should include people who have endured such struggles. But we must recognize that that alone is not enough. I don't talk often publicly about my own background, but I think it is necessary here to put Judge Thomas's life story, dramatic and compelling as it is, into the context of life in black America. Judge Thomas's background is not unique among African Americans of our generation. And virtually all of us over the age of 40 have at least one exceptional grandparent who has been injured and severely humiliated by racism in America. I grew up during segregation with my sister in a female-headed household in a public housing project in Norfolk, Virginia. I attended segregated schools through high school and never knew any white contemporaries. I was able to apply to one college because we did not have money for multiple applications. I was able to attend Wheaton College in Norton, Massachusetts because my uncle put a second mortgage on a house he owned, the only piece of real property owned by anyone in my family, in order to pay college bills. I'm very reluctant to parade that family history in public, but not because I'm ashamed of my background. I am proud of my mother's strength and tenacity and the love and determination she employed in raising my sister and me. I am grateful to my uncle for what he gave to me and to the other members of my family for the encouragement they gave me. I'm profoundly grateful to a high school teacher who taught, inspired, and pushed me to achieve. And I'm proud of them all as strong black people who battled through racism and material poverty to hold themselves in dignity and to forge spiritually rich lives. I don't talk about it simply because it has no impact on my capacity to function effectively as an adult or professionally as a lawyer and legal educator. Moreover, my story is not unique in the black community. And frankly, I don't want people's sympathy or their condescension.
Ms. Greenberg, if you would please. I appreciate it.
Thank you, Chairman Biden. The National Women's Law Center is opposed to the confirmation of Judge Clarence Thomas to the Supreme Court. We do not take this position lightly, and I know that's the case for many of the witnesses who have indicated their opposition. We oppose Judge Thomas because of our grave concerns that based on his record, Judge Thomas does not have a commitment to the core constitutional and statutory protections that form the basis for women's legal rights in this country. Instead, Judge Thomas has taken positions that conflict with women's rights under the Equal Protection Clause of the Constitution, the constitutional right to privacy, and women's rights to education and employment secured by federal law. You did make reference to the report that the National Women's Law Center prepared, and I'll ask that that be made a part of the record. We looked at his record in that report, and I can now say, unfortunately, that Judge Thomas's testimony before this committee has intensified rather than allayed our concerns.
There are differences. There are legitimate differences. There are well-reasoned differences. There are honest differences. And sometimes he'll be right and you'll be wrong. Sometimes you'll be right and he'll be wrong. I mean, that's just the way it is.
I think that one of the major points is that when given an opportunity, Judge Thomas has adopted cramped or pinched views And let me give you an example. I was the Deputy Director of the Office of Civil Rights, the Nixon administration. And at the time in which we administered Title IX, it was actually passed during that period, and we administered Title VI, it was our view that employment was in fact covered. This precedes Judge Thomas. What I think that we have to worry about is, does he, and we do worry about, does he seek opportunities, because that's the way it almost comes down, does he seek opportunities to adopt these very pinched and cramped statutory interpretations? Is he indeed reversing or going backwards rather than forward in providing opportunities?
Later, still another panel testified in support of Judge Thomas.
I am Emily Hart Hollyfield, an educator employed by the Compton Unified School District. I am a Compton Community College senior trustee member. Further, I am the person who seconded the famous motion on Saturday, July the 20th, 1991, at a regular meeting of the Compton branch of the NAACP to support Judge Clarence Thomas, President Bush nominee for appointment to the United States Supreme Court. Mr. Chairman, little did I know that this action taken by the NAACP Compton, California branch would echo all around this nation, waking people up and causing them to really think. I have named this motion, Mr. Chairman, a candle, a flame for mankind. Mr. Chairman, I am supporting Judge Clarence Thomas because I feel that he will make an excellent judge. A judge that will represent all the people throughout this nation. Judge Clarence Thomas is qualified, is a role model, and has developed a philosophy of self-help and self-reliance. And I don't see nothing wrong with that. Senators, at this time, I cannot think of a more timely cycle than now for the self-help and self-reliance program that United States Supreme Court Judge Clarence Thomas will be able to implement as soon as you, honorable senators, help confirm him to this appointment.
Reverend Hagan. During the past decade, Judge Clarence Thomas has called America to greatness. Regarded as a rejected stone by the black leadership establishment, Judge Clarence Thomas has now become the chief cornerstone of brotherhood, human equality, and individual liberty in the land of the free and the home of the brave. Judge Thomas has carved out a pathway for the new black leadership of the future, and he has left it a legacy that is firm, workable, excellent, compassionate, sagacious, and competitive. Judge Clarence Thomas has proven that he possesses those attributes of judicial prudence, integrity, and ability essential to serve as an associate justice of the United States Supreme Court. His character, energy, compassion, and intellect have positively excited the American public, and the public is demanding his expeditious confirmation. Frederick Douglass has reminded us that power concedes nothing without a demand. It never has, and it never will. Kind, genteel, and urbane, Judge Thomas has emptied his life into the lives of the oppressed, the downtrodden, the poor, the forgotten, and the less chanced people of the times.
Highlights from this, the sixth day of testimony before the Senate Judiciary Committee on the nomination of Judge Clarence Thomas to the Supreme Court. The panel will resume its deliberations on Thursday. I'm Paul Duke on Capitol Hill.
After a one-day break, our next hearings highlights are scheduled for Thursday night at midnight. Now stay tuned to Iowa Public Television for Doing Business in Asia, following in a moment.
funding for this program was provided by the Corporation for Public Broadcasting and by the financial support of viewers like you.
This is PBS.
Enjoy more TV worth watching tomorrow.
I just can't believe he has AIDS.
I know. He doesn't look sick.
In the Shadow of Love, a teen AIDS story. Young people and a deadly epidemic.
Is that the only reason you love me? Because my house is empty every day after school.
Well, see how funny it is when it happens to somebody you know.
In the Shadow of Love, it's everyone's story.
Wednesday at 7 on Iowa Public Television.
Hello, Iowa. Мені так сподобались ваші люди і ваш штат, що я захотів його привезти до себе на Україну.
Join Iowa Public Television when it travels to the Iowa farm in the Ukrainian Republic. Meet a Soviet capitalist, farmer Ivan Husar, in the country where there is no word for farmer. That's tomorrow night at 9, right here on Iowa Public Television.